5 minutes.
Okay, we are live.
Let me start, Robert. Okay.
Just a minute. Margub is joining us. Yes, we have him. So we can start. Yes.
Thank you. Good morning. I am Akmal Azad, Director, Bangladesh International Arbitration Center. Welcome, distinguished participants. Today, we are holding our second webinar as part of a series of regular webinars we are trying to float during this crisis period of COVID-19. Our today's theme is application of force majeure clause. Should COVID-19 be included? We have with us experts from the judiciary, RMZ network industry, banking sector, the lawyers community, academics, and arbitrators from home and abroad at this webinar, who will help us guide to face the challenges of dealing with the current crisis. First of all, I go straight to business. I will invite our CEO, Mr. Mohammad Erumi Ali, to say a few words, who joined BIAC as Chief Executive Officer in October 2015. He started his career with ANZ Greenless Bank in Bangladesh in 1975 after completing Masters in Economics from University of Dhaka. In 1997, he was appointed CEO of the bank's Bangladesh operations. He worked with ANZ Greenless in Mumbai, London, and Melbourne. In November 2002, he joined Bangladesh Bank as Deputy Governor and was responsible for driving the regulatory reforms in the banking sector, especially in the risk management and corporate governance areas. Mr. Ali is currently serving as the chairman of the board of AB Bank Limited and the advisory board of Bangla Link Limited. He was made a fellow of the Institute of Bankers Bangladesh in 2001 and participated in many international forums as keynote speaker and panelist. On to Mr. Mohammad Erumi Ali, CEO, Bangladesh International Arbitration Center. Sir.
Thank you, Akmal, and thank you all of you over here. Assalamu alaikum and good morning. It's a pleasure to invite you all to BIAC's webinar on application of force majeure clause. Should COVID-19 be included? I'd like to extend our warm greetings to all of you, and I'm particularly honored, we at BIAC are particularly honored to have among us Mr. Justice Rezaul Hasan, Honorable Judge of the High Court, Mr. Miran Ali, Director, BGMEA, Mohammad Hatem, First Vice President, BGMEA, Mr. Rahel Ahmed, MD, CEO, Prime Bank Limited, Barrister Margub Kabir, Dr. Muhammad Anowar Zahid, Dean, Faculty of Laws, Eastern University, and our international speaker, Ms. Iram Majid, Director, Indian Institute of Arbitration and Mediation. And to bring it all together and make sense for all of us, and those who are hearing our distinguished audience also, it's a privilege to have among us the go-to lawyer, one of the go-to lawyers of Bangladesh, Barrister Sattar. Before we start on the proceedings for today, I'd just like to take your time to introduce BIAC to you. BIAC has been around from 2011, and although the government licensed it in 2004, it took a few years to get it started. ICCB, that's the International Chamber of Commerce, Metropolitan Chamber of Commerce, and Dhaka Chamber were all sponsors, and the initial funding came from International Finance Corporation. BIAC is proud to say that it's the only licensed and globally recognized center for alternative dispute resolution in the country. There are other institutions, well, I'd not like to label them as fake or something like that, but they do not have government license to practice ADR, nor they are recognized by global bodies such as the Permanent Court of Arbitration, The Hague. BIAC is recognized by at least another 20 national institutions and many of the institutions within the country. BIAC actually to promote ADR, first had to create a human resource base in the country, because although lawyers are familiar with arbitration and mediation and all other ADR practices, the others weren't. So there was a need to create a human resource base who appreciate what ADR is all about. And in that respect, we have actually trained about 1,644 persons and conducted over 71 courses, of which 11 were in international forums, including the Singapore Arbitration Center, then the CIR, and other such institutions. As an institution advocating the use of ADR, we work in outreach and through seminars, dialogues, and other awareness raising activities, constantly reaching out to policymakers. And we have held 123 such events, which basically introduced this to the students, to policymakers, and all the people who actually can bring about change or are stakeholders in this whole thing. In the area of actual cases, BIAC has facilitated over 304 hearings and has actually facilitated 100 cases, of which 17 were decided and 3 were mediation. To embed the use of ADR in dispute resolution system to ensure, one, access of justice through an efficient, effective, and an economic alternate dispute resolution process, particularly for commercial disputes, BIAC has actually, after the pandemic, focused on 2 particular areas. One, delivery of justice through contactless process, without contact. And the second is we looked at what has happened in the garment textile industries lately, where many of the buyers, major and minor buyers, actually resorted to the use of force majeure to refuse to perform under the contracts. So the first issue we have actually changed and evolved our rules to become more friendly on a virtual basis. This was necessary. We are now ready to hold no contact virtual ADRs, both mediation and arbitration, and this is supported by BIAC rules. The second issue of the garment industry, we thought this is not only an issue for the garment industry, it is actually a national issue. And most of these issues, most of these contracts were actually rejected, or the buyers refused to perform on the contract on the basis of force majeure. So we wanted to know whether this is applicable, whether you can really use this. And we reached out to BGMEA and BGMEA both to find out if there is a need to look at this more carefully, so that we can have a industry-based response, so that it's not single a particular garment factory or garment industry which is doing it, but a response that will come not only from the BGMEA or BGMEA, but also the government, the central bank, and all other policymakers in this area. So we are moving in that direction, and you are here today because of that issue. We'd like to find out a little more. And as you heard in my in the introduction, that I'm not a lawyer, and this is a very, very, I'd say, a very legal issue, a very important legal issue. I'd rather not show my ignorance by talking any further. So with those words, I'd like to hand it back to Akmal to make the introductions. I didn't go into to introduce all the speakers, to greater introductions, and hand over to our distinguished moderator. Thank you very much.
Thank you, sir. I would now request our distinguished moderator, Barrister Sattar, to conduct the session. Barrister Sattar is an advocate of Bangladesh Supreme Court and head of firm Sattar and Company. Mr. Sattar has specific interest in commercial transactional work and dispute resolution. His practice primarily involves corporate advisory work and litigation, including acquisition of private companies and banks, setting up local companies, advising foreign companies on joint venture issues, foreign investment, local syndication for commercial projects, and drafting commercial documentation generation. Barrister Sattar is also active in the practice of international arbitration. He worked on and appeared as counsel in several international arbitrations held under the auspices of the ICC, UNCITRAL, LCIA, SIAC, and ICSID rules. On to Barrister Samir Sattar.
Thank you. Thank you. Good morning, everyone, and assalamu alaikum. Thank you, Mr. Rumi Ali, for the warm welcome and kind introduction. It is my absolute pleasure to be moderating today's webinar on such an important topic. As you all know, today's topic is on the application of the force majeure clause, and particularly whether COVID-19 should be included. Now, this is a very interesting topic and extremely relevant given the current situation. Whether it is in the commercial sector, the banking sector, or in our daily lives for that matter, the relevance of force majeure has never been so important as it is today. For those who are not aware of the topic, coming from a non-legal background, the concept of force majeure is usually used as a form of an excuse from the performance of the contract. This is in simple terms. A force majeure event is usually an extraordinary event.
Mr. Samir, good morning. Actually, I could not listen to you clearly.
Is my voice not clear?
We can hear you.
Okay.
We can.
Apologies for those who cannot hear me. So as I was saying, that for those who are not aware of the topic, can you hear me now?
Yes.
For those who are not aware of the topic, the concept of force majeure is usually used as a form of an excuse from the performance of the contract. A force majeure event is usually an extraordinary event, which is beyond the control of the contracting parties and include examples such as acts of God, natural calamities, wars, strikes, etc. If pleaded successfully, a force majeure clause can actually relieve the concerned party from their respective contractual obligations for the period of time during which such an event exists or continues. As the current pandemic lingers on, more and more companies and individuals will not only be preparing for an adverse impact on their businesses, but also on the performance on their contractual obligations. Naturally, the current pandemic will have an adverse effect on contractual obligations which they signed up before the beginning of the pandemic. In particularly going forward, more and more companies and individuals actually will need to consider, and I can tell you already that many have already started to consider whether they're entitled to invoke the force majeure clause under their relevant contracts. I'm sure that the audience will also be interested to hear what are their options in cases where they do not have any force majeure clause in place. In such a case, will the existing legal framework come to their rescue? These are burning questions which are currently on everyone's minds. Now, without wasting any more time, let me introduce you to our panel of distinguished speakers for today's webinar. Our first speaker is Justice Muhammad Rezaul Hasan, Honorable Justice of the High Court Division. Justice M.R. Hasan needs no separate introduction. He is surely one of the most thorough judges of the Supreme Court and is extremely knowledgeable. He has presided over the company bench for a significant amount of time and has rendered many notable judgments on company law and arbitration matters. Justice Hasan has also published a very helpful book called The Index of Bangladesh Laws, which is very, very useful for all lawyers practicing in Bangladesh and is also frequently used by lawyers abroad to get an idea of the relevant Bangladeshi laws. During his time in practice, Justice M.R. Hasan had a very successful legal career and also worked with the World Bank as its consultant. I'm very delighted to have you with us, sir. Our second panelist is Mr. Miran Ali, who is the Managing Director of the Bitopi Group and is currently one of the directors of the Bangladesh Garments Manufacturers and Exporters Association BGMEA. He has been directly involved in the garment sector and the garments industry for decades and has been recognized by the government as a commercially important person for his special contributions in the export industry. Thank you for joining us, Miran bhai. Our next speaker is Mr. Rahel Ahmed, who is the Managing Director and CEO of Prime Bank. Now, Mr. Ahmed has had a wonderful banking career and is still continuing, having worked in various multinational banks in Bangladesh, such as ANZ Greenlace Bank and also Standard Chartered Bank. During his banking career, he has also had the opportunity to serve abroad in Dubai for around 7 years, working for leading regional banks there. Our fourth panelist is Professor Dr. Mohammad Anowar Zahid, who is the Dean and Professor of Law at the Faculty of Laws of Eastern University. Dr. Zahid holds a PhD in Transatlantic Business Law from Manchester University, UK, and a Master in Laws from Dhaka University, as well as Dalhousie University from Canada. The next speaker is Barrister Margub Kabir, who is one of my favorites in our legal fraternity. He is a very knowledgeable and effective lawyer of the Supreme Court and is also licensed as an attorney in New York. He has his independent practice handling mostly litigations and arbitrations, both international and local. Ms. Iram Majid, who is our next speaker, is the director of the Indian Institute of Arbitration and Mediation. She is also a lawyer with decades of experience in handling civil and criminal matters. She is also an IIAM certified mediator. She has completed her Master of Laws from Kurukshetra University, India, and has undergone several trainings in mediation from leading universities such as Harvard Law School and Pepperdine University. Finally, our last speaker is Mr. Mohammad Hatim, who is the first Vice President of the Bangladesh Knitwear Manufacturers and Exporters Association, BGMEA. He is also the Managing Director of MB Knit Fashion Limited and Senior Vice President of the Exporters Association of Bangladesh. He's also an Executive Board Member of the International Chamber of Commerce, Bangladesh. Thank you all for being with us. Now, before I hand over to the speakers, or invite the speakers rather, I'd like to just say a few words in respect of the timing and the format of the webinar. I've been requested to let our speakers know that we are working on a very tight schedule, and each of you will have approximately 5 to 7 minutes to provide your views and thoughts on the subject matter, after which we will be conducting an open question and answer session from the audience. And for the audience, if you have any specific questions that you would like to ask, you can leave the same in the relevant box. Depending upon the timing, we'll try to answer as many questions as we can. Now, without any further delay, may I invite Honorable Justice M.R. Hasan, sir, to share his thoughts on the issue of force majeure. Sir, the floor is yours.
Sir, you can speak, sir.
Hello.
Yes, sir, we can hear you.
Hello.
Sir, we can hear you.
Hello.
Hello, sir, we can hear you.
Have I been? Yes, yes. You can hear me. All right.
Yes, sir.
Good morning. Good morning, CEO Mr. Rumi Ali, Director Mr. Akmal Azad, and Moderator Mr. Sami Sattar, all the learned participants and all those who have joined this webinar. And thank you very much for inviting me to share your experience in this respect. And the main purpose of this, as has been pointed out by Mr. Rumi Ali, perhaps is to make a sense of the clause, what is known as force majeure. And my speech looks like, may look like as if I am giving an opinion. Still, the main purpose of it is to help you brainstorming in that, and to help think about this clause, proposal that whether should COVID-19 be included in the force majeure clauses. In this respect, I would first of all say that the proposal, it seems to be, to me, to be a surpluses or a redundant one. Because we'll have to take into consider many things. Whether the contract is between person to person, or between whether the contract contract is to perform by any particular individual, then it will have one kind of significance. And another is that it is the nature of the business, nature of the obligation, that will bear different significance so far as this clause is concerned. Now, first question is, why I have told that this seems to be surpluses or redundant, is because that this is covered by specific provisions of statute, particularly Section 56 of the Transfer of Property Contract Act 1872. Section 56 of the Contract Act 1872, that has made a clear provision that when contract party at the time of, when the contracting parties at the time of entering into the contract is unaware of any unforeseeable situation or event, and subsequently that event happens or takes place and that renders the performance totally impossible, then the contract is void. And it is void without requiring the consent of either of the parties. It automatically or by operation of law ceases to exist, and a void contract need not be performed. So actually COVID-19 or for any other causes or for any other diseases, say a footballer, a singer, or any person whose personal performance is required under the contract, he will be, if it becomes impossible for him because of his being a victim of COVID-19 or coronavirus or any other diseases, automatically Section 56 will come to play and will be exempted from performing his obligation, as a contract will become void. But the situation will be different. This is, I am telling about when the performer is an individual and the proximate cause of his inability or impossibility to perform is the COVID-19. And we should give proper emphasis, due emphasis on proximate cause. It is the proximate cause that must render the performance impossible. In many cases, we may see that the COVID-19 itself is not per se is not the proximate cause that renders the performance impossible. It is either the lockdown or government's restriction under government restriction on movement of traffics under the Epidemic Act of the Epidemic Diseases Act 1987, Section 2 of which authorizes the government to pass certain orders, not wholesale orders in all respect, whatever government desires or wishes to. So if a factory or a business concern becomes unable to perform its obligation under COVID situation, then if the proximate cause is the shutdown or stoppage of traffic, whether through sea or air, then the proximate cause is this government order, not the COVID itself. That's why I have said that, in a sense, this proposal is redundant or surpluses. Even if it does not, even if COVID-19 does not clause is not included within the force majeure, but a situation occurs or even takes place that renders the performance impossible on the part of the promisee or promisor, then it will automatically render the contract void, and a void contract need not be performed. The situation, there might be other situation when there are a set of reciprocal promises to be performed part by part. In that case, Section 55 will come into play, and that will have different significance. And the particular part that cannot be performed maybe relieve the obliger as well as obligee both. This is a different situation. So directly, Section 56 of the Contract Act is has the direct bearing on force majeure clause. Even if this is not included in the force majeure clause, that COVID-19 should be a force majeure situation, then also the Section 56 provisions of Section 56 will apply, as will apply Section 7 and 8 of Sales of Goods Act, as will apply Section 108 of the Transfer of Property Act in respect of the lease. Number one. Number two, it should be kept in mind that it applies only to executory contract. That means the contract which are yet to be executed. It does not apply to the contract which has already been executed. Now, now we are living in a COVID situation which is prevailing globally. So Section 56 will not apply in that sense that now when the COVID pandemic is prevailing over worldwide, then any contract, if any contract is entered into by the parties, then it is very much foreseeable. One of the conditions is that the contracting parties should be unaware of the impeding event like COVID-19. Now, after January 2020 or March 2020, it is no for an unforeseeable event. So, in that case, it is the shutdown or lockdown or a curfew or a stoppage of traffic which might be a cause for rendering the performance impossible. And that will be examined based on case to case. Now, if a company enters into a contract to supply, say, personal protection equipment, we cannot say that COVID-19 will apply in that case or will be a force majeure. There are other contracts when you are providing services or selling services, or we are selling cyber products. So it depends on nature of the contract. When COVID is not a proximate cause in all cases, except the cases where individual performance is required, like that of a singer, as I have told you, or a player might be like these things. In other cases, it is not the proximate cause. Here, proximate cause, this is a term of law, and it should be understood in the very sense in which it is used in insurance companies.
So I think that it is very important that the points that you've made that we pick up on, because the main crux of the issue, I think, as what I understand from your speech is that it is the proximate cause which is the crucial factor, which will determine whether a successful invocation of the force majeure can be done in the circumstances. Another important point that we have taken up from your speech is that whether it only applies to contracts that are yet to be executed. not all
executory
that
contracts.
are to be performed. And most importantly, what struck to me is that now, as the COVID-19 pandemic is unraveling,
Right.
it is no longer an unforeseeable event. So people cannot
Yes.
actually invoke that as a defense or an excuse to relieve themselves from the performance of contract going forward, because everyone will have to assume that risk and go forward if they have to go on with their business dealings. So, sir, I will definitely come back to you.
Subject to provisions of 56. I told you.
Absolutely, absolutely. The law is always there, sir. The law is always there.
Actually, it can misdirect your attention. It can
Absolutely.
misdirect your attention. I repeat, it can misdirect your attention if you focus on COVID-19. You must see whether it was unforeseeable and whether it has become impossible. It has rendered impossible to perform the obligation.
And by virtue of that proximity.
It will vary on several situations. Who is the performer? If it is an individual or a company, whether the contract is already executed or it is an executed one, and what is to be done, what is to be performed. Many things it will depend on, vary according to the various nature of contract and obligations to be performed.
Absolutely, sir. Thank you, sir, for your valuable comments and thoughts. Our next speaker is Mr. Miran Ali. Miran bhai, perhaps you can shed some light on the practical impact of today's topic on the garment sector. We are all aware that there has been force majeure claimed on any occasion, and any other thoughts that you would like to share with our audience.
Thank you very much, and good morning, good afternoon, everybody. One of the funny things is that, you know, in the decades of this, the business existing in Bangladesh, the RMG business, which has reached over $30 billion, to a room full of lawyers, it's going to seem bizarre to you, but it was mostly based upon trust. Trust to a point that we trusted our customers. We trusted them quite similarly to the way that we trust Apple, because when we signed the Apple contract, we probably signed away our souls. And when we as garments vendors, when we go to any company, they ask us to sign vendor agreements, and none of us, with very few exceptions or none, has ever read it. So it's the general course of business. We signed it. Unfortunately, somewhere in there, it mentioned force majeure, which nobody actually bothered to read up on. And then we have this COVID crisis, which for the garment sector has become an existential crisis. It is still too early to actually be able to quantify the value of the liability that our industry is going to be taking as a result of the cancellations and also importantly the pushbacks. Because what has happened is buyers there's a spectrum of behavior among the brands who are buying from Bangladesh. On one hand, we have what we would like to say responsible customers who have honored their agreements. On the other extreme, we have customers who have used the force majeure clause to annul, cancel, terminate all existing contracts, including goods which were already shipped out on the way, actually, or even in some cases at the distribution center, at the port of discharge. So we've had a whole spectrum of reactions. In many cases, we've also got factories who have to now bear with the liability of raw materials that have been purchased on good faith. And unlike our customers, we purchase on letters of credit. So there's, presumably, less room for wriggling out of that. So we have a situation where we have a lot of factories who have purchased raw materials for a customer who no longer wishes to buy that product. We have to either find another customer for that raw material, A. B, we have to find a way of selling it somewhere else. C, we need to find a way of paying for it because we've lost our customer. It's a particular fabric in a particular color for a particular customer for a particular season in a particular market. It's very, very difficult to try and resell it somewhere else. So what is the level of that liability? Well, that depends. That depends on whether customers are able to reopen, because again, we have a lot of faith in the people who do business in Bangladesh with the customers who do business in Bangladesh. And we hope that people, once the confidence in the market improves, that some of the cancellations will be lifted, and has happened. However, we also need to take into account the distinct lack of negotiating skill, the perception on the part of us as manufacturers of I won't call it an inferiority complex, but at least a complex of some sort, where we believe, rightly or wrongly, that we are not in a position to negotiate on certain terms. I personally, I'm not speaking from my association, but I personally believe that the time has come for Bangladesh, or at least for the banking sector in Bangladesh, to no longer accept open terms, open contracts, or any other terms of payment or trade which do not include some sort of a guarantee, without taking recourse of which company is placing that order. And I believe this is going to be something very important, because the greatest thing that has been lost through this crisis has been trust. We trusted our customers, and we've been left high and dry. With that, I would like to pass to the next person. Thank you.
No, thank you, Miran bhai, for your valuable thoughts. I think trust is important, very, very important. However, the importance of the underlying contract cannot be undermined. And I think this corona has actually taught many of us to actually read the fine print relating to the terms and conditions based on which parties can invoke their rights. The next speaker is someone from the banking sector. Now, we know that the banking sector has taken a major hit during the COVID-19 pandemic, as many borrowers are unable to fulfill their loan obligations. Keeping such complications in mind, I would like to hear from our third speaker, Mr. Rahel Ahmed. Rahel bhai, could you please shed some light on the risk factors for the banks and how they're handling the issues so far?
Thank you, Samir. Thanks to you for that great introduction, and thank you to the BIAC leadership, specifically to Mr. Mohammed Rumi Ali, for inviting us amongst this August gathering and discuss this issue, which is the most contemporary one. I am here amongst these super duper lawyers and legal counsels to learn more, and especially after hearing from Miran, the practical overview of the whole situation. Now, as you know, taking cue from Miran, they have been basing on trust with their customers, and we in banking, customers trust us and we trust our customers as well, but we are in management of risk. We're in a business of risk. We manage risk. As you also rightly said, there are certain fine prints that maybe in last 100 years people didn't read. It didn't occur in anyone's mind that what could be a force majeure. I have been in banking, under the able mentorship of Mr. Mohammed Rumi Ali. We started 25 years back. In last 25 years, I personally have not come across invocation of force majeure in any of my relationships or corporate relationships that I have ever handled. They've always heard about it. But this corona has kind of opened our eyes, and it has opened lots of new windows or thoughts to be provoked over the next century, I'm pretty sure. What we have seen, starting from, I'll keep it very short, from the supply side, and textile and garments has already been talked about by Miran. Other than textile and garments, in most of the import-based customers that we handle at our banks, what we started seeing back in Jan of this year, that China being our major global trading partner, we started seeing some disruption on the supply side. Now, the first thing that came to our mind that the Chinese suppliers should have invoked the force majeure clause, that they're not being able to supply on time, or they wouldn't be able to supply goods on time or stuff. But we haven't seen, and we had been checking with our trade service guys on a regular basis that are we seeing any kind of requests coming in from any of the suppliers, and especially from China, because that was the place where it all started from. We didn't see any of those coming in. Now, what has happened that between February and March, we started seeing the Europe and US being affected. So our manufacturers who are in the exporters side and trying to export goods out of here, they didn't see any kind of messages coming in from the global brands that, sorry guys, due to force majeure, we can't be making payments and stuff. Now, this is where the breach of trust or the thing which Miran referred possibly happened, or to an extent happened later on. Now, when our own production got standstill towards the end of March till about end of April, I would say, because towards the mid of April, we know that on a limited scale, some of the production facilities were opened and stuff. In the meantime, in the bank, what we have experienced that the importers who imported goods and their commitments were there to make the payments. If it was a USAMS LC, there were certain commitments to be met. The importers came to the banks and they requested us that, you know, because of the lockdown in Bangladesh or all around, the business has come to standstill. Can we kind of defer the payment? Now, if it was against an LC or in whichever format that may be, we saw plethora of messages going out of our trade service division to the suppliers requesting for an extension of the payment obligation. And I can tell you from the data that I have for my bank, merely about 1% was responded. And 1% of those requests were responded, and maybe less than 1% kind of agreed to extend those maturities. So as a bank, under the LC terms and the UCP regulations and everything, we were bound to make the payment on behalf of the client. So in majority of the cases, we had to create forced loan and meet the import obligations. So that is where we were kind of in a catch-22 as a bank. I mean, had it been so that, the force majeure clause could have been invoked by either of the parties, unfortunately, my very little layman understanding of the legal terms of the contract laws and everything, it says that unless until the both parties agree and they are they can prove that they are totally incapacitated to perform the obligation as per the contract, they cannot. Now, in Bangladesh, obviously, if the importer wanted to invoke, our understanding when we were talking to the customers, they kind of sought advisory services from us that would you advise us to invoke on force majeure? Now, this is where we also consulted some of our legal counsels and stuff. Unfortunately, what we understand, and thanks to Rumi Bhai for giving that introduction, I mean, also you suggested that, whatever has been written in fine prints in the contract, unless until it is clearly spelled out that what would be included in, what would be the definition of force majeure, whether COVID-19 would be acceptable or not, that was never there. I mean, nobody ever thought of it. So majority of the opinions that we received at that point of time that, sorry, it can't be invoked at this point of time. So from the risk management perspective, both on the supply side and on buy side, what we have seen on the incoming imports, we didn't get much of a response from the suppliers with regards to the extension of the payment obligation for the importers who are our customers at this end. And on the garment side, garments or textile or majority of the export side, Miran has already covered that. I mean, they were kind of, held hostage or they went high and dry because the buyers, they just say that, sorry guys, we put our hands up and say that we're not going to take receipt of the goods anymore. As a bank, the only support that we received so far, thankfully from the central bank, in form of certain regulatory relaxation, I would say, in terms of some of the usance payments and stuff there, the payment obligation date could be shifted or could be extended. Thanks to Central Bank for supporting us through on that front. But that doesn't take away the ultimate underlying risk of the crux of the matter. I mean, because majority of the importers have faced issues with regards to their business, which has come to a kind of a standstill since March. Things have started to pick up in June, but as we all know that things are not back in normal, but we are trying to cope up with the new normal.
I think the things are and will be evolving over a period of time, and whether the force majeure would be a part of the daily norm in the contract is only time will be able to tell.
Absolutely.
And the successful invocation will depend on the facts.
Absolutely.
At this stage, thank you, Rahel. At this stage, may I invite Professor Dr. Muhammad Anwar Zahid. Dr. Zahid Cheb, we've heard about the different views of speakers from different sectors. Perhaps you can enlighten us with your academic perspective on the issue and whether this should be more formalized in some sort of a law or whether this should be included as part of the legal regulatory framework, considering that COVID-19 is perhaps here to stay at least for some foreseeable future. The floor is yours, Dr. Zahid.
Thank you very much. I thank BIAC to invite me, and I thank you to give me an opportunity to speak on this issue this morning. As I said, I'm an academician, so my approach will be academic for sure. I know I have some students here attending this program, so they will be how it's called benefited from my academic perspective, I think. First of all, we need to know what force majeure is. I think for the students' perspective, especially, it is to be defined first. Force majeure is occurrence of something unexpected and beyond reasonable human foresight and skill, which make the performance of the contract impossible and discharge the parties from their contractual obligations. That's all about force majeure. Now, question is whether we can invoke COVID-19 to be included in the force majeure clause or not. The first answer is it depends. Yeah. It depends how. It depends on whether the clause, namely the force majeure clause, there at all or not. That's the first question. If the clause is there, then we have to see how the clause has been crafted. Yeah, whether clause has defined the terms that may invoke COVID-19. For example, it may have terms like pandemic. It may have some terms like epidemic, illness, or a widespread outbreak of diseases. These terms could be invoked to include COVID-19, arguably, of course. Apart from these, what is the particular terms, sometimes we see in the context some general terms are used like act of God or circumstances beyond the parties' reasonable control. These general terms can also be invoked, arguably. So it depends on the circumstances where the parties may argue for inclusion of it, and whether the court will take such argument or not, because court's approach is restrictive. Court of laws, the court do not take the court of law does not take what is called the invocation so easily. So their approach is restricted. Now, question may arise: how about if no clause is there? Could you hear me, please, Mr. Samir? Sattar? Hello?
Yes, I can hear you
Okay.
clearly.
Now, question may arise: how about if no clause is there, no force majeure clause is there, then what could be an alternative? Then through, as we see in international practice, the court sometimes resort to the force, rebus sic extentibus exception, which is this exception to pacta sunt servanda. Pacta sunt servanda principle requires the parties to comply with the terms of the contract. But in exceptional circumstances, which has changed the whole circumstance fundamentally, in that case, the principle of rebus sic extentibus can be resorted to. So where in this case, the court may resort to, to absolve the relying parties from the obligations to carry out the contract. So this is to specifically answer the question whether COVID-19 could be included. So my answer is, academically, of course, answer is whether there is a force majeure term at all or not. If there is, whether particular terms have been used that may attract the inclusion of COVID-19, terms like pandemic, terms like widespread outbreak of diseases, or even in general terms, act of God, whether can we argue that COVID-19 can be included by these terms. And second is, if no clause is there at all, no force majeure clause is not there at all, then what could be the alternative? As I say, in that case, the principle of rebus sic extentibus could be resorted to, which is rare though. But what I am telling you is about it is from my what is called study from international commercial practices. May I have some time, or I should?
Yes, you have 1 minute.
1 minute. Okay, and to successfully invoke this, this excuse of COVID-19, one of the important things the relying party has to prove that he has direct impact of this, as already one of the speakers said, there must be approximate impact.
I think that is the most important point from what we understand from Justice Emar Hasan's speech, that and you are supporting that statement that the main crux is the proximity issue.
Exactly.
Whether the proximity is grave enough for the party to successfully plead the excuse or defense of force majeure will be a matter which will depend upon the particular facts of a case and on a case-to-case basis.
And one more duty on part of the relying party is whether he or she has taken steps to mitigate the loss, mitigate the the circumstance.
Absolutely.
That's also important. That's also
Absolutely.
important.
Absolutely. Yeah. I think at this stage, I would like to invite our next panelist, Barrister Margub Kabir. Margub, you know that these days a lot of our time is being spent and opinions are being rendered around the applicability of the force majeure clause, which again hinges on the proximity issue. From a counsel's perspective, can you share some of your thoughts on this?
So anyway, thank you for having me here. It's a pleasure always to come at events of BIAC because of all this gathering and the important people who are always present in the sessions. I'll straight away go to the point. The point that you have asked is a very important issue right now. Much has been said about force majeure, but what I would actually want to highlight is what force majeure is not. So the perception there is that, the COVID-19 being a situation which took everyone, at a surprise, is considered to be a force majeure. But typically, force majeure is something which hampers your performance obligation. It is not something which basically, if an event gives rise to economic hardship, that's not a force majeure. If an event makes your performance of a contract difficult, that's not a force majeure. Force majeure is something which stops you from performing for a certain period of time, it defers your performance. The common misconception that we have that is prevailing not only in Bangladesh but throughout the world, or at sometimes is being misused, is that this COVID-19 situation is being taken as a force majeure event. I would like to take something from something which Mr. Miran Ali has stated, that in our RMG sector, what we are seeing, that I personally have experience in, which I'm seeing, is that some large retailers in Western countries are raising force majeure issues to cancel their orders. As he has pointed out, that some of these orders have, some of these contracts have already been performed. Goods has been shipped. Some goods are even at the port of discharge. But what the buyer has done basically is sent a notice saying that, that due to COVID-19, we are unable to perform this part of the contract and we cancel the order without any monetary consequence. Now that is absolutely illegal. You cannot terminate or cancel a contract just because of economic hardship. What amounts to force majeure event would be when you are prevented from performing that contract temporarily. For example, if you cannot sell your goods, if a buyer cannot sell his goods due to COVID-19, that is not a force majeure. If the buyer, for example, the store in which he's supposed to sell it is one specific store that gets burnt out, or there's an act of God, there's a storm or something, that can be a force majeure. So what I'm trying to say is that economic hardship cannot be a force majeure event. The second thing which I want to point out is that from the experience of, representing this, is how COVID-19 as a whole, or force majeure as a whole, has impacted proceedings regarding this. So usually in consequence of such illegal cancellations, what is done is, number one, negotiation. And, you try to negotiate with the buyer, telling them to, take the goods, pay even at a discount to take the goods, But what we have seen is that, the lack of skill set that us personally, Bangladeshi vendors have is, it's directly affecting this. Mr. Rumi Ali has, in a previous webinar of BIAC, has highlighted this, that we need this skill set of negotiating contracts. We need to read the fine print. This has basically shown us that there is no bypassing the fine print. You need to be advised properly, even if it's a small contract or a large contract. You need that advisory for you to proceed on.
What I found, sorry to interrupt, what I found interesting is that, as Miran Bhai was saying, that in such a multi-million-dollar, billion-dollar industry, what we're seeing is that no one is actually negotiating the contracts, and primarily based on trust. And even when we are advising clients, when we ask for the underlying documents, all they can show us is 2-line, 3-line emails, and no sales contract, no negotiated sales contract. So I think this would be definitely a lesson for all of us to learn, to read the fine print and to negotiate a contract, as you rightly say, through appropriate skills. Please continue. Sorry to interrupt. I thought I'd just add that perspective.
No, absolutely. You're correct. I have exactly the same view, that we really need to read the fine print. I mean, all contracts are based on trust. There's no, it's a good thing that you have that trust, but you need to codify that trust into a document, because you want that trust to prevail all throughout the contract period. When there is a problem, when the weather is not good, you need that document to support both, the buyer and the seller. It's not unilateral, it's bilateral discussions, right? Now, what I personally, due to the shortage of time, I'm just gonna go right to the point, is in relation to experience that these vendors have faced due to lack of dispute resolution provisions in the contract. Now, when there is a problem, what has happened is that, for example, if I will speak about a US buyer. When the US buyer has illegally canceled the contract, what these Bangladeshi vendors could do is to institute a proceeding in the US court against that buyer. Now, what has happened? The buyers have instituted, for example, a buyer goes into the US federal court and files a complaint against the vendor for not performing their part of their obligation. As you know, the court proceedings throughout the world are disrupted. Courts are not sitting all the time, the proceedings are delayed and all that. Now, this is a time-sensitive issue. Just because you are a victim of an illegal cancellation does not mean that you will quickly get a relief. So, the delay in getting a relief will actually force you to, settle for something which you are in normal circumstances you won't.
Absolutely. And
Now,
here, at this point, I think when we were discussing earlier, most of these exporters, as you rightly say, they do not have a proper dispute resolution forum. Either they're thinking it's going to be too expensive for us to go abroad and sue the buyer for damages, or secondly, they are slightly a bit more conscious that that it may affect their business relationship going forward, and they may not get orders. As a result of which, they're being pressurized into, or impliedly pressurized into, accepting a huge discount. So I think that problem will be there.
Yeah, you're correct, and I think it's the first one. It's just that much thought has not been given to the fact that you need a dispute resolution clause. What has been given is that whatever there is standard document that is sent by the buyer, it's signed and sent back. Now, in this situation, what has been done, a complaint, even if a complaint is filed, but due to the disruption in the proceedings, it takes a long time, and in the end you have to settle for example 50% of what you have settled in the normal circumstances. But what happens to vendors who have dispute resolution clauses? For example, this is a practical thing which has actually happened. A vendor who had an arbitration clause in their contract quickly could set up a tribunal, quickly could file their complaint before the tribunal, and the tribunal, started proceedings.
Absolutely.
The moment the tribunal started proceedings, the buyer had to come in and give their defense. At that stage, they did not have any defense. So they took adjournment and they settled. They started the settled provision, and the amount that they received, those vendors, were, I wouldn't say much higher, because the other vendors still have not received anything. But it would, I can guarantee you.
And most of us in Bangladesh also do not know that if you have an appropriate sales contract with an appropriate arbitration clause, you can actually get third-party funding from abroad to actually run your case.
Absolutely. This is a hot topic right now.
Lack of knowledge from our side. But we are where we are, and hopefully, like I said, this pandemic will teach us a lot of new tricks, a lot of new skills, and we'll slowly need to adapt for that. I know I'll have to cut you short because I note that I have 2 more speakers and very limited time. But thank you, Margub, for your valuable thoughts. Very practical, and I'm sure our audience will be highly benefited. Our next speaker is Ms. Iram Majid. Ms. Majid, maybe you can shed some light from an Indian legal perspective as to how matters are being dealt with in India on the issue of force majeure. And do you think more and more people should be engaging in mediation to resolve their issues as opposed to going for a fight in litigation or arbitration surrounding the application of force majeure?
Thank you, Mr. Sattar. First of all, I would like to thanks to the BIAC for inviting me, and Mr. Akmal sir, and Mr. Rumi Ali sir, and yourself for giving me the warm introduction. So as far as in India, we talk about the COVID, as we know that the COVID has impacted almost all the industries, like the business industries, the school industries, and everything. And it's because of that, now we have to invoke this clause, the force majeure. So it depends upon the case to case and vary from the contract to contract, and also depend upon the proximity. So if we talk about the employer-employee relationship, so there are lots of cases which is coming up in the court these days. But again, the court is not listening you, because every day there are different notifications coming in from the government side. Sometimes it is for the behalf of the employee, and sometimes it is defending or protecting the employer. So if we want to go to the court, so they are asking the urgency. And again, they're not listening to it. If we talk about the Hero Motors, that is one of the most leading business organization in India. They are cutting off all the salaries of the employer and employee. We're talking about the malls, the biggest malls in India. They're going into the, the shopkeepers. They are using the force majeure clause. They're not being able to pay the salaries. Sorry, pay the rents. So they are also invoking these clauses. If we talk about the airport, so the major case is the airport authorities, like Mumbai airport and the Delhi airport in India. They are dealing with the airport authority on the revenue sharing basis. But these days, they're not been able to fulfill their contractual obligations. So they're having 3 months time for renegotiate on those terms. And the same way, we are facing different kind of situation here. But thanks to the dispute resolution, if we talk about the Industrial Dispute Act for the employer and employee, so it opens a new window for the ADR clauses and for the mediation, online mediation. So now we are using the dedicated platform for the online mediation, where we need not to go for the virtual. It is different from the virtual kind of hearing. It is completely based, completely give you it generated the agreement to sign, or agreement to mediate, or settlement agreement, or it will generate the, schedule the sessions. So we are using the dedicated platform. One of the platforms which I am using for doing my online mediation is PeaceGate app, www.peacegate.in. So we are facing this kind of difficulties, and thanks to this ODR now, and I myself is doing ICC mediation and lots of mediation, including the matrimonial, or the commercial and the termination, this kind of contract. This kind of disputes I am dealing in the online.
I think previously the issue of ODR was more of a fashion. Now it's more of a necessity. So as we progress further, I think more and more online dispute resolution will pick up, and more institutions like BIAC and everyone will be gearing up for conducting their hearings online. And it has its benefits. It saves costs.
It has its benefits, certainly.
It has its benefits. For sure.
And suppose I'll discuss you one small case, but it differs from, like, suppose it's the IT department, and if you are using the server, you're using the data, so that will not come into the force majeure things. And see, one of my colleague, one of my friend, he was working in Saudi Arabia, and he came here in India for limited period of time. But during that time, the lockdown happens. It is the lockdown, it's by the government. So everybody understand that it's a period of hardship. But his government is not allowing him to come back. And the job recommendation is like from the IT department. So he has to lose his job, and he's not been able to use this force majeure clause, and nothing can help here. So we are all bound here. So in the end, see, because it's a time constraint, so I would like to conclude it. See, we, the lawyers, sometimes we are not understanding the nuances of the drafting of the clauses. So once we are drafting the clause, we should be careful about the boilerplate clauses. So there are certain boilerplate clauses which also include the force majeure and the hardship, like the governing laws, etc.
If I try to elaborate force majeure clause, my client is saying, why are you trying to make my contract so complicated? Are you trying to bill me more by making it longer? So we are stuck in a paradox where we can't go one way or the other.
I understand.
Thank you for your valuable thoughts. Our last speaker is Mr. Mohammad Hatem, who is involved with the Exporters Association of Bangladesh, and is ideally placed to share his thoughts on how it has impacted the exporters. Sir, the floor is yours. Is Mr. Hatem there?
Hello, he's not.
Hello, is Mr. Hatem online?
No, he doesn't seem to be connected.
Okay, perhaps he can join us when he can. Meanwhile, I know that time is a pressing issue, and we have some interesting questions. If BIAC permits me, then I can move on to the question and answer session.
Go ahead, sir.
I think you should.
Okay, thank you, sir. I wanted to pick up some questions, and one interesting question. Now we're getting many questions from the floor, but one interesting question is that regarding the standard of proof, and my question is specifically directed to Honorable Justice M.R. Hasan. Is he still with us?
Yes, Mr. Samir.
Sir, we've always learned that the sanctity of contract is paramount. And now, in order to avoid any liability...
I cannot open my video. Can you help me from there?
I think
Sir,
you
we've requested you to open your video, sir.
Yes, you can open it now.
Sir, you can open it now. BIAC has
Yes, we can see
all
you.
right. Thank you very much. Thank you very much. I have had the opportunity to hear all the learned speakers. In fact, I'll very quickly answer to some questions because
Sir,
I have heard this.
May I
come to
pose,
your point.
may I pose the question very quickly that we've learned that the sanctity of contract is paramount. And now in order to avoid any liability, do you think that the standard of proof should be higher than other civil cases?
Yes, yes. I'm very quickly going to your to answer your points because time is very short. In the meantime, I must say that the share the audio of Mr. Miran Ali of BGMEA, indeed they have performed their part of the contract. They have produced the goods. Now it is the duty of the buyer, foreign buyer, to pay the price. And indeed it is done under an irrevocable letter of LC. And bank is not at all worried about the underlying contract between the parties, whether it is in 2 lines or 200 lines, it doesn't matter. As far as there is an irrevocable letter of credit and there is no discrepancy and there is no fraud, they are entitled to receive this their money, number one. Same thing with the bankers as well, so far as LC is concerned. And you know that under the Epidemic Act, government can make some orders regarding restrictions of movements, many other things. But it is the ambit of Bangladesh Bank to pass an order under Section 46 of the Bank Companies Act, so far as banks are concerned. Banks have also performed their contract. They are part of the obligation by disbursing the loan. Now it is the absolute responsibility of the loanee to repay the loan. Now it is a relationship between the parties to negotiate for extension or reduction of rent. As I have also written an article on bringing the interest rate to single digit, that is a different issue. Or Bangladesh Bank may, in the public interest, pass an order under Section 46 to requiring the banks to renegotiate the interest or to extend the time. And then again, what is public interest will have to be interpreted by the court, not by the bank, Bangladesh Bank itself. Anyway, that is a different issue.
No.
And the Indian legal expert, she has also rightly pointed out these things, and she has pointed out one more thing, that shopping malls are not paying rents. In fact, their cases are covered by Section 108 of the Transfer of Property Act, Clause E. And India has faced a lot of cases and problems in this respect. And law is very much clear. As long as you are occupying the premises, you will have to pay the rent. Because it is a closed transaction, you have executed a tenancy agreement already or a lease agreement already. And this is a closed transaction, executed contract. Lessor has or landlord has performed their part. Now tenant will have to perform their part as well. Now coming to your question, sanctity of the contract must be upheld, because one of the speakers told that it is question of trust. It is question of trust, a question of mutual trust and confidence on which the trade and business practices and commerce are going on. So it will have to be maintained at any cost. Arbitrators are not supposed to enter into the trappings of a court. But I want to clear it, make it a clear point that as far as this clause is concerned, what we want to call force majeure, a court must try to, arbitrators must try to enter into the trappings of the court and will require strict proof. Burden of proof must be very strict, because someone has performed his part of the contract and another is trying to escape from perform the obligation. As Mr. Margub Kabir has rightly pointed out, that financial hardship or economic loss, these are totally immaterial and extraneous consideration. Immaterial, and this proof must be beyond reasonable doubt, as we find in a criminal case. It should not be merely preponderance of probability. I think.
Absolutely. Thank you, sir. I think just on that point, because we are facing a lot of queries from different companies and individuals regarding rent and payment of rent and everything. An interesting question that has been posed, and perhaps Margub as a counsel, you can share your thoughts on this, that in case of a commercial space lease, And if the contract is yet to be performed, so for example, if an individual has taken a lease of commercial space and given a non-refundable advance amount, can he or she in such circumstances claim a refund due to a force majeure event? Because these are practical questions which will be actually very important for the audience.
Actually, he cannot. He cannot because he unless he can prove that this has rendered the the developer of the lessor to perform his part of the obligation. If because of the COVID-19, I am sitting from my room and there are four to five apartments, for multi-story apartments, they stopped their work for last 3 to 4 months. Now they have started their works. This exactly comes under section 55 of the 54 of the Act. During that phase, they don't have to pay any installment.
Yes.
That's all.
Margub, do you want to add anything? Margub, do you want to add anything?
They can avoid only if, for the sake of your understanding, say that property has been acquired by the government, say, and it has become totally impossible. Or the person who is supposed to develop and lease has become bankrupt for some other reason, and the contract has become impossible. Then only they can do it. But otherwise, it does not come under section 56 or force majeure clause or frustration of contract. It comes under section 54. Phase by phase, you'll have to perform your contract.
It's all on the thing. Margub, do you want to add anything on this?
I just what Sir has said,
very briefly.
It's exactly that's the case. But what is happening practically is that all the, as you I'm sure you are advising as well, that there's a lot of requests for reduction of rent or for non-payment of rent or deferment of rent. Now this is not a force majeure typically. Force majeure, as Sir has rightly said, is, for example, if the building is destroyed or the place itself is destroyed and there cannot be rented out, then it's a force majeure. But hardship is not. Now what is being done is basically you can only negotiate, and what is being done is discounts are being given due to the economic impact, but it's not due to force majeure. It's due to negotiations being carried out between the lessor and the lessee.
Okay.
And regarding, if you're speaking of taking a cue from the advance that has been given, whether a refund can be sought, it depends on the terms of the contract. And typically, if you're allowed to terminate the contract, you can seek a refund. But in case of COVID-19, which is not considered to be a force majeure, then it's hard for you to seek a advance, return of the advance. But you can still do so, because what even the government is saying, in relation to residential property, don't evict people, but in relation to commercial property, even banks, like large commercial entities, are seeking discounts from landlords, and that is being
absolutely
done.
Absolutely. Mr. Miran Ali, are you with us?
Yes, I am.
Miran bhai, from a businessman's perspective, if the performance of a contract by a buyer is not possible due to its business being temporarily closed, okay, so we have a foreign buyer who cannot perform their contract because of their business being shut down. What are businesses doing, exporters doing here in Bangladesh who have already ordered or are yet to just place an order on a back-to-back LC for their raw materials? So what practical steps are they taking?
Okay, well, I need to clarify one point here. The majority of the problems that we have encountered as exporters has not happened where we have an irrevocable letter of credit. The majority of the problems has occurred where we have what we call a contract, which is a sales contract.
Sales contract.
That's where the problem occurs. Now, ultimately, as Mr. Margub mentioned, that almost none of these sales contracts has an arbitration clause. So in most cases, we've been left to try to negotiate with the customer. And what the excuse that they gave, the reason they gave to exercise the clause of force majeure was because their inability to conduct their business. Not because of economic difficulties, but because of the lockdown, their shops were closed, therefore they have no cash flow, therefore the clause applies. Now, I'm not a lawyer, but that was the issue. It is not naivete that makes garments exporters blindly sign contracts. It's the reality of both the local competitive scenario in Bangladesh within the manufacturers. And at the same time, it's also the reality that this is a global business. As long as there's another supplier in China, Vietnam, Cambodia, who's willing to accept those sales contracts, unless I am significantly cheaper or faster than that supplier, I have to accept the same terms. So it puts us in a very difficult negotiating position. I would like to call upon your sympathy in this regard. But what we do need is some sort of structure for sales contracts, a structure which all companies buying apparel or any other product in Bangladesh, but mostly apparel, buying products in Bangladesh must comply to a standard format, which is not onerous to the point that we lose business. At the same time, it's not so flexible that it allows people to take advantage of any potential situation, because we've had COVID-19 now. The world is due for solar flare. Now, would a solar flare count as force majeure? Because that is very much an act of God, and that will knock down all satellites and global travel for an indefinite period of time. So we need to have a standardized format, and I think that this is what our plea to all the learned colleagues here is. Thank you.
Okay, thank you for your
insight.
Yes,
if I can, Mr. Sattar, intervene. Thank you very much for giving me the thing I think we haven't talked about is the power imbalance between the two parties over here. You are dealing with two parties where particularly the large buyers, have tremendous. And I think the industry position was very much weakened after the Rana Plaza crisis, where I think I was in the board of one of the American Alliance, the US Alliance for Workers' Safety, whatever. They actually got together. They got together and made themselves even more powerful to impose certain, I'm not saying they're good or bad, they're good because they actually protected the workers. But actually, that's what happened here. I think that the aftermath of that Rana Plaza tragedy, I think the power imbalance became even greater. But this is not only a garment industry issue. Let me tell you from my banking experience, LCs are open on the basis of a pro forma invoice. This pro forma invoice contains no ADR clause. So you are always open. And the other thing I'd like to emphasize is that there is a lack of awareness and also a lack of understanding and appreciation of what ADR can do. And I'd like to draw the attention of the legal community, because this is what I've been talking about. And thank you very much for Margub for mentioning that it was only not the last that event I said that. I've been saying it for the last 3 years I've been with BIAC. So I think we need to do something.
I think it's time that all these contracts should be well negotiated with appropriate dispute resolution clause. And I like the fact about your power imbalance, because that was one of the questions from the floor, that how can the force majeure be asserted in cases where most of the small garments or factories depends upon third-party buying houses, right? So because there is the power imbalance, so they're being asked to sign or honor their whatever obligations are being thrown their way. Hopefully, with newer contracts being signed going forward, we'll have appropriate arbitration clause and a proper dispute resolution forum, whether mediation or arbitration, that can take place between the parties, and they are not left without a forum where they can exercise their rights. Now,
if I may, I just want to add one thing. In this regard, what the associations, for example, the BGMEA and the BKMEA needs to step in. Because, for example, for small factories or for small entities, suppliers, it's hard for them to frame appropriate clauses. This is where the associations needs to come in to protect their members or to protect their community. Force majeure cannot be drafted, all provisions cannot be drafted, as we know. But as much as we can, for example, this pandemic, it happens in 100 years. So that's why in most force majeure clauses, you don't have a pandemic, but you do have act of God, which, act of God necessarily contemplates a pandemic. So this is where the associates needs to come in and have standard clauses, which, their members can opt in.
Yes, certainly. I think we should all take learning points from here, especially regarding the dispute resolution forum. BIAC is doing a wonderful job training a lot of in-house counsel as well.
Mr.
Yes,
Samir, just a second.
Yes,
I think that I would supplement a few words only.
absolutely.
That is you say a buying house, or for that reason an indenter, who are working at the level of pro forma invoices. They are indeed working as agent of their respective principals.
Yes.
So it is a problem between their the buyer and supplier, and they are in the mid. They are working as principals, whether as a buying house or an indenter. When there is an indent, it simply stipulates the price of the goods, the time due till which for 1 month or 15 days or two months this price will remain valid, and then how the shipped good will be shipped. These things are covered by pro forma invoices, in fact. But the court, when there is a clear-cut obligation, will not look into this pro forma invoice. Number one, they will see what is the proximate cause, what I again and again emphasis. Number one, and then you see the BGMEA side told that they have some contracts, 2 lines, 3 lines, 5 lines contracts. Now, if you look to Section 7 and 8 of the Sale of Goods Act, even on that basis of the Section 7 and 8 does not exempt the foreign buyer from performing their obligations. When this is already a concluded contract and goods has been sold after a particular price, it is a future good. In case of future good, only with perishes before supply.
Sir,
something like perishable goods, but clothing, garments are not perishable goods. So Section 7, 8, they cannot take resort to. They are entitled to get back. And it has been pointed out again and again, economic hardship, closure of warehouse or shopping mall, it will not exempt the buyer from payment of the goods. It is their part of the business, because risk is very much attended with each and every kind of business. They will have to take this. They will do business for 12 months or 12 years. In 1 month or 2 months or 1 year, there might be some loss. But for that reason, they cannot be allowed to breach the contract, which does not attract Section 56 or Section 56. They will have to make oblige. Now, whether we can or not, that is a different thing.
Sir, I think your points are very valid, and you're going into the merits. But what I understand, the main problem is the lack of a dispute resolution forum. Because what I would invite BIAC to do is to have a training with the Garments Association to actually have some sort of a dispute resolution forum to make them aware that they may be held, in the absence of any forum, you cannot vent all these.
In that case, I would advise you to please note, if possible, train our suppliers, foreign suppliers.
Absolutely.
Yes, our foreign suppliers to stipulate about the governing law, it should be Bangladesh. Governing law should be Bangladesh, and the forum should be, forum, whether it is Arbitration Council or a court, should be Bangladesh. So that they don't have to go to USA.
Definitely, that is a favorable point. But negotiation
as you have told, it won't be cost effective, and it will be lingering and all these things. So our business people should be told to stipulate in their contract that the governing law should be Bangladesh law and the forum should be Bangladesh forum.
Inshallah, as hopefully our bargaining power strengthens, we will definitely try to.
Depends on the extent of the negotiating parties.
Absolutely. As we mature into a more stronger bargaining position, maybe we will definitely press for that. But for the time being, my request would be for BIAC to organize trainings with Miran Bhai is here with the BGMEA on the importance of sales contract, having a proper dispute resolution forum, and also about third-party funding for huge contracts, because
Also can be
there
a
are funders out
negotiation.
there who are able to fund the Bangladeshi exporters to
Negotiation.
recover their claims.
Hatem is
Negotiation
on a
drafting.
joint
Yeah.
now, and we hear from him.
Yes, Dr. Zahid.
I'm saying,
Mr.
apart
Yeah.
from the dispute resolution, as you have proposed, there should be some training on drafting contracts, negotiation of the contracts. These are very vital things, which may equip our industry better to negotiate with the foreign parties. Thank you very much.
Okay, Mr. Ali, if you wanted to add something, I know I have overrun by 10 minutes, so I will wrap up the question answer session with your last comments. Mr. Ali, you were saying something?
No, I think Mr. Hatem, who was also invited to speak,
We have him here, yes.
Yes. I will request the moderator, Mr. Sattar,
Fine with it. If BIAC is fine with the timing, I'm happy to invite Mr. Hatem to share his thoughts.
A short few minutes.
Mr. Hatem, are you there?
I think we've lost him again.
No, we have him. Yeah.
No, I'm sure he's there. I see him there. Mr. Hatem? He's gone again.
No, I think we have lost him. Okay. We are in your hands, Mr. Sattar.
No, because obviously the limitation of time, and I think we've had a wonderful discussion. This would conclude our question and answer session. Thank you for your patience and great answers to great questions. I wish we had more time to continue this very informative dialogue that's going on. And like I said earlier, that I would request BIAC to increase the awareness especially with respect to sales contract tie-up with Miran, Ali's association, the Garments Manufacturing Association, because out of the 100% cases that I've advised so far on pandemic, I can say at least 90% of the cases did not have a proper sales contract with a proper dispute resolution forum. And now I understand, which they say it's all based on trust. With this point, I would be handing over the remainder of the webinar to my favorite person, Mr. Mahbub Rahman, the president of the ICC Bangladesh, my dear uncle, and arguably the most respected mentor, senior mentor of the business community. Uncle, I hope you're there, and thank you for making the time to be with us here today. I know you're extremely busy, and we would be very, very grateful if you can kindly share some closing remarks on today's webinar. Over to you.
Thank you. Thank you, Samir. In the first place, I'm not a lawyer, neither a contract expert. Here, Margub, Samir, and many others, including Iram from India, and also the learned judge, Justice Hasan. So you all know about the subject that you are discussing. This is something I am an ignorant person. But one thing I can tell you from my experience in the business for more than almost 55 years, that we do not go for contract. We always go for trust. And only negotiation is only the price. When you buy something, you say, oh, this is this much of price, this is this much of price, and so on and so forth. And this is the period of supply and the shipment period. That is also not very much strict, and anyone is not adherent to that. But as far as the force majeure clause that you are now discussing, unless you are having a contract, you cannot enforce any such clause. And here in this case, the COVID-19 is something that we have not seen in the last 100 or 200 years after this Spanish flu. But here in this case, some of the provisions of this COVID may apply, not everything, that when the government by official notification, no flight in and out of the country is not allowed to fly. No ships can come in and go out. In all such cases, no transports can fly in the road. In such a case, only I think such force majeure may apply. Otherwise, such situations in many other cases, if it is there to, then in that case, anybody or anyone will apply a force majeure clause for some reason or the other when they do not like to perform a contract. So from that point of view, I would consider that force majeure in this case, you can see, you can look into this. It is just a new one, but unless, again, I would like to repeat, as the Justice Hasan has mentioned, that if you are having a contract with what is called pro forma invoice, they are all provisions are in favor of the seller. So they can go for anything. So you should have a properly negotiated contract in order to ensure any such clause, not to speak of force majeure, but any other clauses, that it has to be there. So what I would consider in this situation that has developed out of nowhere, we are in this, and in our lifetime, we have not seen such a pandemic in any other area. So such a condition, as it appears, it will not end so soon. Apparently, all these situations are taking a new turn every day. And in this situation, you may consider to look into it more seriously, that whether such situation for our seller or for our buyer, such situation, whether this applies, the force majeure in certain condition. However, in our case, we are being a weaker party, a smaller country. Even if under the contract, the buyer or the seller is supposed to give me the compensation or the damage, but unfortunately, we cannot enforce. The reason being, because we cannot, as you, Samir was mentioning, the filing a suit in the federal court. Many of our seller or buyer, they cannot do that. So for that reason, as you have said, that there should be a forum which will settle in such cases. BIAC, as you all know by now, that we have all started this being there is no forum of settling anything outside the court. So we, three of our chambers, we are joining together and doing it. I'm speaking here today, of course, not as a ICC chair. I'm talking
as the chairman of BIAC.
As the BIAC. So here in this case, we have three chambers we are joining together, the Metropolitan, Dhaka, and ICC. And we tried it, we have tried our best to form this forum in order to bring about a resolution of such disputes in the case of people who cannot just go ahead with the court cases. But however, still I must mention to the audience who are attending today's seminar that still people are quite averse to the idea of having this kind of a settlement. Still, the people are running to the court. And here in this case, it is your help that we need to push forward that such dispute settlement can be made without going to the court in a shorter period of time and under a better circumstances and win-win situation. And I would consider that your support in this case will be very, very helpful, because you will advise your clients in order to bring about these.
No, here it is also very important, because just on that point, recently I was speaking to an international law firm, and they wanted, in relation to a potential recovery of some money from these foreign buyers, and they wanted to see a sales contract with an arbitration clause. And surprisingly, not even a jurisdictional Bangladesh court. They want an international arbitration clause in the contract for them to actually arrange for third-party funders, because third-party funders who would actually fund all these claims in London or USA to help these Bangladeshi exporters to effectively exercise their rights, they are not going to come forward or be forthcoming without any proper dispute resolution clauses. So it is very, very important. Perhaps BIAC's next webinar can be on trust versus negotiated contract. So we can have one on that, and then we can start from there.
Agreed. And Margub has been, associated with us from the day one. And I think that your people like you, the more younger professionals, can push it through, so that it can take its position, and it will be very, very helpful for not only for the clients itself, even for the country in its country's rating.
Absolutely.
Also very, very important. But thank you very much for giving your time. And I would consider that we are all thankful to you for all your support. And in the days to come, we look forward the greater attention from your side to make this BIAC take its real position in the stage.
Jay.
Thank you.
Absolutely. Thank you. That ends today's webinar. I'd like to hand over back to BIAC. That is bye-bye from me. I hope everyone enjoyed today's session, and the question answers will certainly be very helpful for all our audience from a practical, not only from a legal perspective, but also from a very practical perspective. Thank you once again to Honorable Justice M.R. Hasan Sahib, sir. Thank you very much for taking the time to come to today's webinar. Miran Bhai, Rahel Bhai, everyone who has participated, Professor Zahid, our distinguished guest from India, Ms. Iram Majid. Thank you all, Margub, for attending today's webinar. I'll hand back the floor back to BIAC for last vote of thanks. Thank you.
Thank you very much. Yeah, thank you very much, Mr. Sattar. And I'd like to thank all of you for coming here. I think what we have discussed today is an extremely important subject for the future of this country. We all know the major export of the country and country's future hinges on this very important issue. Miran has spoken extremely well, and I think we have taken notes. And as we have taken notes from everyone's speech, I think we have a lot of material to go through. We have already reached out to BGMEA on this issue, and we hope to establish more contact and create some sort of understanding. Once we get that understanding, we can take the step forward. I think you're absolutely right. I go by your recommendation that there has to be, as I said in my opening speech also, that the response cannot be just from BIAC or from the lawyers or from the garment industry. It has to be a well-coordinated response in which the regulators, I mean Bangladesh Bank, the government, the Ministry of Commerce, everyone has to, all the stakeholders have to work together, because if we cannot just change things if anybody works independently. So with those, for hoping that this happens in future, I need the help and cooperation of everyone. BIAC needs you. So, and also the country needs you. So thank you very much once again. We'll wish all of you good health and goodbye. And I'd like to thank in the end our chairman for coming, sparing a few minutes for us. And needless to say, he has been the prime mover of BIAC. It is his vision that created BIAC way back in the early 2000s, and we got the license, as I mentioned, 2004, mainly to his effort. And the fact that it really took off is all because of his persistent commitment to the institution, which I hope will continue in the future also. Thank you again. Allah Hafiz. I love you.
Thank you.